Welcome to this presentation on applying the CARE Act with a focus on professional judgment. It's based on extracts from my book, and at the end I'll tell you how you can buy it for a discount price and also how you can get a free digital copy. My background is as a social worker, manager, trainer, and policy developer. I'm not an academic. I wrote this book following an approach from a publisher who'd read an article I'd written about the lack of guidance on applying the CARE Act for social workers. And as there was no sign of any guidance forthcoming, I was persuaded to write this book. The first edition was published in 2017, and as you can see, the second edition came out last year. So why focus on professional judgment? In setting out what social workers in England must know, understand and be able to do, Social Work England specifies in Section 3.1 of its professional standards the importance of working within legal frameworks and using professional judgment. So this is the aim of the session, focusing on two particular professional judgments. There are other professional judgments that are set out in the CARE Act, and I'll list these later, but this session will be focusing on these two, and I'll explain their importance as we go along. The particular importance of the CARE Act for social work is that it sets out the legislative mandate for these following core tasks. The CARE Act is distinct in this respect, as this doesn't occur in other legislation that social workers use regularly, such as the Mental Health Act. But it does no more than set out a framework and the parameters within which professional judgments can be made and upon which good practice and local policy can develop. The legislation comprises of the Act, the regulations and the statutory guidance. You won't often have to look at the regulations because they are repeated in the statutory guidance, and as you would expect, there is more detail in the statutory guidance. You would rarely see the statutory guidance printed out, but if you did, it is the length of an average novel. It's almost as long as Harry Potter's Philosopher's Stone, for example. So it includes these elements. Just a digression on must and should, in case you're not familiar with the legal meaning of these terms. When must is set out in legislation and indeed in guidance, it's what it says on the tin. It has to be applied, no ifs and buts. Where it says should, there is more discretion. A rule of thumb is that a local authority has to apply a should unless there is a good reason not to do so. You might think this doesn't happen very often, but we will be looking at an example of this later. There have been 11 judicial reviews in relation to the CARE Act, and I go into detail about all of them in my book, except for the most recent one, which was reported towards the end of 2023. As we have seen, this is what the law does not do. There can be times when you will need to refer to lawyers on matters of interpretation of the law where it's not clear. But it is important to remember that lawyers are not experts on the application of the law to real life situations. This is where social workers have the expertise in how the law should be applied, particularly in relation to professional judgments and making ethical decisions. It's helpful to look at the term legal literacy in this context. I like this definition from Research in Practice, which focuses on connecting legal rules with professional priorities and ethical practice. I find that when I'm reading about legal literacy, it's often a one-dimensional definition and focuses on simply social workers having to have a good understanding of the law. But it's more than that. It's the application of the law, which involves the relationship between the law and social work principles. In my view, there are 5 areas set out in the legislation where social workers have a significant level of professional judgment. Firstly, in relation to eligible needs, and secondly, in relation to meeting needs. And it's these two that I focus on in this presentation. But in my book, I also include the following 3. In this next slide, I'm going to locate these 2 professional judgments in the care and support pathway. This diagram is taken from my book, and as you can see, it shows the direction of travel from first contact through to review. I'm going to be looking at eligibility determination and also care and support planning, because it's within that process that decisions are made about meeting needs. I will touch briefly on assessment of needs and also on the duty and power to meet needs. So let's look at the eligibility framework and locate the professional judgment decision to be made within this. The first step is relatively straightforward. The second step is more complex. However, there is a lot of guidance set out in the care and support statutory guidance. It's in the third step of eligibility determination where professional judgment is particularly important, because this is where an evaluation has to be made about significant impact on well-being. There are 2 elements to this decision. Firstly, is there impact on the individual's well-being? And then secondly, is it significant? And in the decision about significance, this is where professional judgment particularly comes into play. Well-being is set out in the statutory guidance. However, there is no guidance on what is meant by impact, and neither is there any guidance on what is meant by significant, precisely because this is where professional judgment applies. Even though you may have determined that there is significant impact on an individual's well-being, there may not be a duty upon the local authority to meet their eligible needs. This doesn't require particular exercise of professional judgment. However, it is an important part of the process. To give you an example, let's just look at this first one. If a carer is willing and able to meet all of the eligible needs of the adult, then the local authority has no duty to meet their eligible needs. In practice, it's more likely that a carer will meet some of their eligible needs and not all of them. These are the other circumstances where the local authority may not have a duty to meet needs. In my book, I use the term agreed needs as shorthand for these eligible needs that the local authority has a duty to meet, but you won't find this term used in the statutory guidance. So let's look at how the professional judgment on significant impact on well-being applies to a case example. Mr. K is one of the case examples in my book, and these details are a stripped-down version. The first part of the assessment is finding out what Mr. K wants and finding out what he can and cannot do. The request for help has been prompted by the fact that Mr. K's daughter wants to stop coming in every day to cook him meals. They want to find out if they can get help with an alternative. Mr. K wants to know if he can get help with cleaning and laundry as well as cooking. As part of the assessment process, Mr. K was referred to the reablement team. This is standard practice in all local authorities where individuals have difficulties with daily living. And the aim is to both assess what they can and can't do, and also to help them learn and relearn skills and develop confidence. The conclusions in relation to meal preparation and cooking are and cleaning and laundry. Mr. K clearly meets the first criteria of eligibility determination. So the next step is to consider his difficulties and inabilities and to determine what outcomes he is unable to achieve. The specified outcome of managing and maintaining nutrition applies in relation to cooking. Maintaining personal hygiene applies to doing his laundry, and maintaining habitable home environment applies to cleaning. You will note that these are listed as A, B and F because that is how they appear in the statutory guidance. So how might significant impact on well-being be considered? What follows is a brief outline in relation to his inability to be able to cook, and I go into this in more detail in the book. First consideration is the well-being criteria, and then impact, and then how significant is this? Is it simply a matter of averting a decline in his health, or could there be additional significance and impact in relation to his mental health? At this point, the eligibility determination will have been concluded, and the conversation with Mr. K would be moving on to how his needs are going to be met, and considering what is required to stop this inability having significant impact on his well-being. Mr. K is likely to say, well, the answer is easy. I need funding for a home-cooked meal. This could be regarded as simply a preference, but it is possible that not having a home-cooked meal could have an impact on his mental health. That is something you would need to determine. The meeting of needs takes place in the context of care and support planning, and I'm going to look at the key professional judgment that takes place about ensuring that there are sufficient resources to meet the eligible needs that the local authority has a duty to meet, the agreed needs. This diagram from my book includes all the elements of care and support planning, but we're just going to look at the element on the left-hand side of the diagram, which is indicated by the yellow highlight, and we're going to look at personal budget sufficient to meet needs. This is what a personal budget is. It's the sum of money that is deemed necessary to purchase the resources to meet an individual's needs. And many of the elements of this decision-making process require professional judgment. This is what the statutory guidance says. It must always be sufficient to meet the person's care and support needs, must include cost to the local authority, must take into account regional preferences, decisions should be based on outcomes and value for money, and the local authority may take into reasonable consideration its own finances and budgetary position. I'm going to run through the personal budget pathway with an emphasis on those elements that require professional judgment. So I'll just be skimming over the remainder. What follows is taken from the new edition of my book, and of course it's only a model to help you with the complications of reality. The starting point on the left is agreed needs, and the end point is the personal budget. The next step is to estimate how much funding is required and come up with an indicative budget. The statutory guidance says that this should be shared with the individuals concerned, but in many local authorities this doesn't happen. And this isn't a breach of the regulations, as it is only a should. The key consideration is this indicative budget sufficient to meet needs? Will it be sufficient to purchase the resources that are deemed essential to meet the individual's needs? In reaching this conclusion, these factors will have varying significance. I will be focusing on those elements where professional judgment is required. Desired outcomes and preferences have to be taken into account. What is meant by taking into account was clarified. In a judicial review, there is no duty to achieve the outcomes which the adult wishes to achieve. And it's the same for reasonable preferences, which also must be taken into account. Well-being applies here as well as in eligibility determination. And this is what the statutory guidance says. Value for money can also be an important consideration, and social workers have a role to play in this. Affordability is a complex and contested area, but statutory guidance doesn't say much. In fact, it's simply what is set out in this paragraph. It has never been tested in judicial review, although there are many complaints that go to the local government ombudsman, and I distill and set out the key findings in relation to affordability in my book. Although each of these preceding elements feed into the final decision about sufficiency to meet needs, my view is that you have to refer back to the eligibility determination and significant impact on well-being, because needs have to be met to the extent that their impact on well-being is no longer significant. How might this apply to Mr. K? He wants a home-cooked meal. An eligible need has been established, and this is what the indicative budget comes up with, which is not what Mr. K wants. So, taking into account the relevant factors, is the indicative budget sufficient to meet his needs? Is it sufficient to ensure that the impact on his well-being is no longer significant? The final decision is that of the budget holder or panel. Now, the decision has to be whether the budget is sufficient to meet needs. The panel or budget holder may wish to take into account other factors such as affordability, and indeed may wish to review the professional judgment. In this next slide, I summarise where professional judgment does and doesn't have a key role to play in the personal budget pathway. These are the key steps. Devising the care and support plan is a key task for social workers. The indicative budget is an administrative decision, but the evaluation of the indicative budget must take place using social work professional judgment. As we saw, the signing off of the personal budget takes place from a panel or a budget holder. But in setting out the personal budget, the taking account of desired outcomes and preferences, that requires social work input. Likewise with promoting well-being, social work professional judgment may have a role in considering value for money and affordability, and it is essential in the decision about sufficiency. That's the end of the presentation, but to finish off, I'm going to refer you to some additional sources of guidance. Firstly, there is the revised edition of my book, which draws on my experience of running training courses on the Care Act and working in policy development on the application of the Care Act, and incorporates learning that is available in the public arena. There is more detail on professional judgment and also defensible decision making, which is about making sure that decisions can be defended when challenged by individuals, solicitors, the Ombudsman, and judicial reviews. My book also takes into account the proposals about capping care costs that may come into force in October 2025. The approach taken in my book is to set out the legislation in a way which is helpful for social workers, but I don't express any opinion on the legislation in the book itself. If you want to read my opinions, go on to my LinkedIn site and you can see lists of articles that I've written on the subject of the Care Act. The Good Assessment Practitioner's Handbook is a useful guide which incorporates an ethical dimension. Also useful is guidance from NICE in relation to social work with adults experiencing complex needs, and the ethical approach to meeting needs in adult social care from PASWA, the British Association of Social Workers. You can find this on their website and you don't need to be a member to access it. If you would like to buy my book, you can get it direct from the publisher at a 20% discount. you quote this code, and this is currently working out cheaper than buying it from Amazon. If you'd like a free digital copy, you can get this by reviewing it on Amazon, and you don't need to buy it from Amazon to do so. And if you can give me evidence of purchase and the review, I will ensure you have a free digital copy. Thanks for watching this video. I hope you found it useful.